All rise. The Court of Appeals Division 1 is now in session.
Thank you, folks. Have a seat. All right, and good morning, folks. We are here for oral argument in 1 CACV 23-0384, which has also been consolidated with SA 23-0108, Arborcraft versus Arizona Urban et al. As you may or may not know, we do live stream and record these proceedings. So please, when you approach the podium, give your name and the party you represent before you begin. According to our current protocol, we are now again resumed the use of the podium with our clock system, so you should be able to see it without any challenge. Each of you has a maximum of 20 minutes per side. You're not required to use the entire time. We do require that you keep track of your own time based on those clocks. They do count down, they don't count up. So the time showing is the time remaining. If you wish to reserve time for rebuttal, you can announce it. We're fine knowing that that's what you're looking at. It helps us look at our questioning. But ultimately, it is your job to keep and reserve your rebuttal time. We recognize that, never mind. Please keep in mind, we have read the briefs. We've obviously had a stay hearing with you folks where we discussed some different things and a hearing with regard to the consolidation of these cases. We are familiar with the issues. We have conferenced the case beforehand, so you don't need to repeat your briefs. What we'd ask is that you highlight on your arguments that you think are important for us to focus on. And with that, counsel, I invite you to approach the podium.
Thank you, Your Honor. All right. May it please the court, I would like to reserve 5 minutes for rebuttal. I will, of course, keep track of my own time. Your Honors, this whole case boils down to the argument that Arborcraft has asserted that
I'm sorry, Counselor, could you just, for the recording?
Oh, I apologize. Yes, my name is Shayna Balch Santiago, and I represent all of the defendants in this case. This case boils down to the argument asserted by Arborcraft that even though Arborcraft never bothered to have my clients sign a confidentiality agreement, even though it never bothered to identify what information it considered to be trade secrets, it never told my clients that it considered certain information to be trade secrets, that my clients should have somehow magically understood what was designated by Arborcraft as trade secret information.
Counsel, does keeping things under lock and key suggest secret?
Well, Your Honor, respectfully, I don't think that happened here. I do want to get to...
I understand that, but my question is, so do you agree that keeping something secured constitutes intent to keep something a secret?
In certain circumstances, yes, Your Honor. I don't think that was the instance here, but for example, the Coca-Cola, methodology on how you create Coca-Cola. If that is kept in a safe, if it's kept under lock and key, then that might probably constitutes a trade secret under the relevant act there. But based on the allegations that are made in this case, I respectfully submit that the information was not kept reasonably secret to satisfy for trade secret protection.
Is the level of protection at issue here, and if so, then what are we to do with the court's finding that it was sufficient?
Well, I would like to take the steps the steps that the court identified as reasonable steps to maintain secrecy. I would like to take those one at a time because I think that it would bring some clarity to the panel, if I could do that, Your Honor.
It's your time.
All right. So fast forwarding to those issues that are identified in the court's order, the court essentially ruled, my reading of the trial court's ruling, is that the reasonable steps that it believed Arborcraft took were password protection and limiting access to information. Your Honors, I would like to highlight this issue of password protection because I think it might be a bit confused based on the briefing. In making this argument of password protection, I respectfully submit that Arborcraft is playing fast and loose with the facts. Because what they're trying to imply is that every time my clients accessed the company iPad to access this customer list, they had to actually type in username and a password. The evidence that came out during the evidentiary hearing, the undisputed evidence, is that those iPads were provided to my clients preloaded with the Jobber application already on it, and that it was Arborcraft owners that actually entered the password onto those iPads. And Your Honors, the password that was entered was a default password that was Arborcraft 1234. That was preloaded onto the iPads and provided to my clients. My clients did not have to re-enter that password whenever they were using those iPads. So under those facts, and I have the cites, Your Honors, to the record on that. The fact that the default password was preloaded, that's at app 337 to 39. That is Defendant Griner's testimony at the hearing. Also app 353 to 54. That is Schmidt. I should also note for the panel that one of the owners of Arborcraft, Clayton Sherwood, was identified as the person most knowledgeable as to a variety of topics. One of those topics that he was identified as the person most knowledgeable about was user access and permissions of Jobber. And at the hearing, he testified that he did not know if the iPad was given with this application preloaded. He did not know if there was a default password that was used and entered in to access these databases. That's the person most knowledgeable on those topics. And those sites are app 301 and 302.
But counsel, aren't you asking us, because the court found with that evidence that Arizona Urban, or no, Arborcraft, made reasonable efforts to maintain the secrecy. Aren't you asking us to find that that was an abuse of discretion based on the facts?
It was uncontroverted testimony, Your Honor. There was no, my clients.
But so let's take those facts. The court had those facts, and the court found that with that, Arborcraft made reasonable efforts. It's not that they gave it out to the public. They gave it to 2 trusted employees to use and be able to access. Let's take that as true. Isn't that still a reasonable protection? It's not that it was out there for anybody to look at. It was the person with the iPad.
That's not entirely true, Your Honor, because there's an additional fact here that came out at the hearing, and that was that one of my clients, Defendant Griner, was actually asked by Arborcraft to use his personal Apple ID number onto the device. That was linked to his own personal card. When he returned the iPad to Arborcraft following separation from the company, Arborcraft did not deactivate that Apple ID number, and that information was still loading to my client, a former worker. It was still downloading information to his iCloud. He actually had to contact Arborcraft and demand that Apple ID be taken off of that iPad, because again, it was linked to his credit card. He didn't want that information loading to his other devices. So
was the customer list loading this way?
And let's be clear, the entire customer list.
Yeah.
Well, the customer, so there's 2 issues here, Your Honor. The customer.
Let's start, was the customer list, the entire customer list, loading to his personal device through this?
The information on the iPad was downloading to the cloud. The customer list in the form that it is in this case at Exhibit A to the motion to dismiss, that was a printout from QuickBooks, which my client did not have access to.
So why does it matter that this iPad was doing this. It's not the customer list.
My understanding is the client information in the jobber application was downloading to his devices, which
So
does
that an
have client
employee
information.
could go on the day of a job and do the job, but that's not the same as an entire customer list, past, present.
The testimony came out at the hearing that the information in the Exhibit A, the QuickBooks PDF, and the information in the jobber database, that the information mirrored. It was the same content.
But not complete. I mean, Jobber did not include the entire list. It just had
Yes.
an accurate statement of it.
No, my understanding is it was all
Is
of
that
the
evidence
information.
that was presented? That they
Yes.
were, I mean,
That-
mirror is different
Yes.
than duplicate.
Let me grab that. That was from Patricia Bravo's testimony. Give me one moment here, Your Honors. I have that pinpoint site. Bravo testified during the hearing that it was her job to manage the list and verify the client information, that's at app 318 to 319, and that it was her job to reconcile the information from QuickBooks and Jobber to make sure the information was the same. And that was at app 322 to 324.
But that does not say that the information on the Apple, on the iPad, was a duplicate. In other words, it doesn't, that's not testimony that that the client list was duplicated into the Apple system. She just was responsible to reconcile. So for example, if an address was different, a phone number updated in the Jobber app, she'd update it in the list that was maintained on a separate computer.
And maybe I'm not fully understanding the question, Your Honor, and if I'm not, I apologize. But the information, it came out at the hearing that the information from Jobber was uploaded to QuickBooks, and from QuickBooks it was reconciled and went back to Jobber, that the data was the same. You might run reports differently, the reports might look different, and the exhibit in this case, Exhibit A, is a report that was run out of QuickBooks. That report out of QuickBooks had things like the customer name, the customer address, phone number, contact information. All of that same information was also available in the Jobber database.
All of it, all at once, at all times?
Yes, and my understanding is there's actually more information in the Jobber database because that was also the system that was used for invoicing
Okay.
clients.
Let's say that this is an accurate characterization, and then let's say that you have related it in full. My next question is, what's the standard? What are we to do with that information? Because if I understand you correctly, all of this was presented to the Superior Court, correct?
Yes.
Okay. And then looking at all of that information, the Superior Court made a decision, and it said, notwithstanding what you just recounted to us, I find that they kept it secret enough to qualify as a business secret. So now, on appeal, what are we to do with that argument?
Well, we have asked for a ruling from the panel quashing the preliminary injunction.
Right. Well, let's start with the standard. What's the standard?
The standard is, I believe, abuse of discretion with regards to the judge's findings.
So we owe that some deference, right?
But, Your Honor, if this were to stand and reasonable steps to maintain secrecy was nothing more than entering a default password of Arborcraft 1234 once on an iPad and never requiring workers to ever enter it again, and in fact leaving an Apple ID number linked post working relationship, then that almost nullifies steps to, it renders that element meaningless.
But that was the argument that you got to make to the Superior Court, and the Superior Court rejected it after hearing from the witnesses and hearing the evidence. Here, our review is an abuse of discretion. Was it an abuse of discretion for the Superior Court not to accept that argument?
Yes, Your Honor.
Was the Superior Court right that they spent $370,000 developing the database?
No, Your Honor, that actually is not supported by the record. It was a lower amount. It was close, but that actually was not supported by the record.
What's the lower amount that's
The
correct?
lower amount that they stated, and actually it wasn't developing the database, it was marketing efforts, but it's $350,000. So it's about the same, but that was overall marketing efforts, and that was not tied specifically to the development of the customer list at issue.
So some significant part of the $350,000 was expended developing this list, right?
I don't believe that testimony came out at the hearing. It was a statement that they had spent approximately $350,000 in marketing efforts.
So the statement that they spent that much money would be, if a finding, it would be an abuse of discretion from your point of view?
Yes, Your Honor.
Okay. I have a quick question about bonds before time gets away from us. You appealed the issue about the bond, and I would agree, sort of, if I pick this up naively, that $5,000 in a business case could almost never be a reasonable amount of bond if you're going to meaningfully impact a business in business litigation. But where did you give Judge Thompson the opportunity to get that issue right? Because I didn't see in the appendix materials furnished here where you had asked for a specifically higher bond and what you had supported it with.
We asked in the motion for reconsideration, where we expressly raised this issue with the judge.
And what was the amount you sought?
We asked for an amount that would take into account the fact that it would essentially put my client out of business.
I'm sorry, was there a number?
There was not a specific number, no, Your Honor.
Okay, thanks.
One of the issues you've raised, and I think I wanted to just tap on this, is your client's ability to take in the new customers. Would you agree that under the order that if someone were to cold call your client from some other source other than an advertisement that your client sent them, even if that person happened to be a former client or a client of Arborcraft, that your client could take that call?
No, my reading of the order is the opposite, actually, Your Honor, because the order specifically states that my client must cease contacts with anyone who happens to be on the list. That's something that I've tried to coordinate with opposing counsel as far as logistical considerations, especially pending this appeal. But my reading of the order was that my clients could not do business with anyone on the list, regardless of where that source came from, regardless of if it is a personal family friend. There's references on the list to Bert's, to my client's
Counsel,
son.
let me just, you don't have much time left. I want to cut to the chase. You're paraphrasing. At paragraph 2 of the operative provision of the injunction, your people are precluded from contacting persons on the Arborcraft client list. Contacting is an affirmative step that you must undertake, right? It doesn't preclude passive receipt of contacts from people,
No.
does it?
I'm actually not paraphrasing. There is the phrase cease contacts. It's either in another portion of the preliminary injunction order or it's in the order on the motion for reconsideration. That exact phrase
Okay.
is actually
I'd appreciate a page on that. Maybe in your rebuttal you can look for that so you save time. But I'm seeing App 28, paragraph 2, precluded from contacting persons on the list. And we're going to ask other counsel the same question.
Page, I don't have the app site, but it is on page 4 of the preliminary injunction order. Also appropriate is an order that defendants cease contact with any persons on the Arborcraft client list.
Where is it on page 4 of the PI order?
It is under the heading return of the client list and return and refrain from contacts with Arborcraft clients.
Okay, so your clients were ordered to cease contact.
Yeah.
So your clients were ordered to cease contact, and they are precluded from contacting, which is that's a verb. So it's a transitive verb, but it's a verb. So your clients have been forbidden from doing particular things. I'm not seeing how that precludes someone else, not your client, from doing the reverse.
We would appreciate that clarification, Your Honors, because I respectfully submit that it is vague. The fact that I've had to confer with opposing counsel on this issue and seek clarification, I think is indicative of that.
We'll confer with your opposing counsel momentarily about the same subject. Counsel?
Thank you. Counsel?
Thank you. May it please the court. Nathaniel Hill, attorney for Appellee Arborcraft.
Hey, counsel, can we just jump in on this? We
Sure.
discussed this on the phone 2 months
Sure.
ago, all of us together. I don't think page 4 is an operative provision of the preliminary injunction order. Would you agree? It's decisional. It's explaining the rationale. The order is setting out requested relief, standards for issuance of a preliminary injunction. It's analysis. It's not operative. It's not the operative order part of the order, right?
Yeah, I would agree. I would submit that it's coloring and helping understand what the court is asking the parties to do insofar as looking at what happened.
Sure.
Further to the discussion about the court's analysis of the reasonableness, and then the court is crafting an order that is designed to enable Arborcraft to protect its trade secret, and then also at the same time enable the appellants to continue in business without benefiting from those. So when it says cease contacts, I read that as, if you've established contacts here, let's cut those off, right? And going forward, you cannot go contact people on this list unless you can establish that there was a prior relationship before they joined Arborcraft.
I think that creates issues of defensibility for you, and I'd say I don't think it's part of the operative provision. I do agree with you and the premise of Judge Faria's last question, as I hear it, which is that it explains the wind-up and there are different forms of the same verb. The part that says it is order is on page 5, right? Like that's the next page, right?
Right. I would agree that what you're
Yeah.
focused on
Yeah.
is the preliminary injunction.
Yeah, page 4 is not the operative provision of the order as the, anyway, so paragraph 2 of this preliminary injunction, precluded from contacting, I mean, that is prospective, right?
I would agree with that interpretation.
Okay, and so I'll get all the way down to it. The thing I was most concerned about in the special action petition was the citation to this case Alpha Tax Services, and it was about how even if you're not allowed to solicit, it's just the idea, you know, even if you aren't allowed to solicit under a non-compete, it's not solicitation to passively receive a phone call from somebody who you wouldn't be allowed to solicit. Your discussion of page 4 makes it sound a lot like if they talk to someone before, they can't receive a further voluntary phone call from such a person. I think that would be an extension of the law if this order were read to mean that. It seems easily defensible if it's prospective. If you're saying they can't receive phone calls passively, I'm troubled by that. Can you respond?
I appreciate that question. How I would respond is that there certainly needs to be a balance where the reality is, and this is something that we discussed in our telephonic conference on the emergency motion, which is appellants sent marketing out into the universe, and who knows who of all of these people, we still have not been shown who all of these individuals are, and so there has to be a way to manage the past use of that, the past improper use of the customer list.
That would be called a damages claim.
Sure, and so that, but then when the call comes in, is that a violation of the injunction?
Not the way he wrote it. He said contacting. How are they contacting a person if after the past wrongful mailing of something for which you have a damages remedy, they take an incoming call? You're saying that the contacting language prohibits them from taking the call?
Well, is this customer calling in response to a solicitation that was made by benefiting from the customer list?
So you're answering my question with a question. I think you interpret this contacting language to preclude some species of incoming calls after the date of the injunction. That's very clearly your position.
Some species of it. I would concede your point that I'm detecting here, which is that if an individual on their own goes on the internet, finds appellants, rings them up on the phone, and does this entirely independent of any influence of the customer list, that's a legitimate contact.
Okay, so you're saying because there's a past improper solicitation, they can't take a phone call in the future, and so we're going to just break a few eggs to make an omelet, and we're going to preclude incoming phone calls because some of the people calling them might be people who were improperly solicited.
No, I would disagree with that insofar as we have coordinated as counsel with that clarification that if a call comes in then they'll report to us what that call was, and we can have a meet and confer as to whether or not that incoming call was influenced by this process. Again, I would point back...
Is there a court order of record, if we look back, that encapsulates that conferral that you just referred to?
I mean, it's encapsulated in, we'd initially filed an application for contempt and then withdrew it based on our consultation.
Yeah, I'm not sure how you meant it, but there's no court order from Judge Thompson that memorializes a settled understanding as to how that works.
Correct.
Okay, thank you.
Correct. So, appellant's argument that a trade secret remedy should consider restrictive covenant analysis has been rejected by the Arizona Trade Secret Statute. The AUTSA expressly states that that chapter displaces conflicting tort, restitutionary, and other laws of the state providing civil remedies for misappropriation of a trade secret. This is the holding in Orca Communications v. Noter, not the Court of Appeals, but the Arizona Supreme Court holding, wherein the Supreme Court held that a court cannot read or add language into the AUTSA, right? And what appellants are asking this court to do is to apply a restrictive covenant analysis, thereby injecting a new law that's not there. The Orca Communications Supreme Court case rejects that. The AUTSA rejects that. I want to go back to, so I don't run out of time, the issue of the bond that Judge Jacobs had raised, which is every authority that I have located states that that is discretionary. The only case cited in appellant's reply is a case that says that a government entity doesn't need to put up a bond. We've not seen any authorities or any other information indicating that the bond amount is not appropriate or that some alternative bond amount would be appropriate.
So it's that they didn't develop the issue. It's not that $5,000 is a reasonable amount.
That amount is discretionary to
You can abuse discretion, right?
It's possible. Some of the federal authorities interpreting this same rule have held that it may not be necessary on any level based on the discretion of the judge. In spite of the statute or the rule of procedure saying something to the effect of no injunction shall issue unless there's security put forward by the party receiving that.
If we assume for the sake of discussion that the requirement is to be meaningful, is $5,000 adequate?
Yes.
Why?
Because the trial court made an assessment of several things. Likelihood of success on the merits, probability of irreparable harm.
Counsel, I apologize for interrupting, but I'd like to back up because I don't think that the bonding requirement is consistent with, I don't think you can conjoin the analysis and say, well, because they're probably going to lose, $5,000 is okay. A bond to be effective is the amount that if counsel turns out to be right and you turn out to be wrong, which I'm not saying is the case at all, right. But hypothetically, I think the trial court is supposed to assume that if its order fails, what would adequately secure damages to them? So that's what I understand. My question to you mean is, how is $5,000 adequate to answer that query?
Well, the reality is that there's a party that misappropriated a trade secret, right? If that turns out to be wrong, that they would have to establish something more than what's been put forward. I would. Okay. I know this isn't the answer you're looking for, but all of my research on this issue pointed to this was purely discretionary. If the trial court had sought clarification prior to requesting, to issuing the order, he would have solicited that. And the number was set,
So
he determined it was reasonable.
Fair to say that if you're going to challenge the amount of a bond that the trial court sets, you probably need to come in with something to say. It should be X amount, and here's why. We're going to lose this much business over the next year and a half, and that is why we need a bond of this amount, not just a bond. I mean, if it's left to the court's discretion without any specific request, how do we say the court abused its discretion?
Right. My response is that's a rational approach. I'm not aware of any rule or authority supporting that. I haven't seen anything. I looked at the issue, and the best I can come up with is that it's up to the trial court's discretion, and under the federal rules, they've held that it's not even necessary if decided by the trial court.
But don't we decide that a trial court abused its discretion either because it's got the rule of law wrong or it made a mistake a clear mistake in the facts. That's what we have to have.
I
And we don't
agree.
have that on the 5,000, do we?
Say your question again?
We don't have a clear mistake on the facts for the 5,000. There's been no evidence on the other side to say it should be more.
Correct.
And the judge was, though you dispute whether they actually had to issue some sort of security under the rule.
My understanding of the rule is yes, that as in Arizona, some security should be provided.
And it's just a discretionary amount.
Correct.
Okay.
Correct. So one key fact that came up before is, and this is an indisputable fact, and this is the telephone call that happened on September 14th, 2022, exactly 1 year ago to the day, who knew we would be here, wherein Arborcraft called appellants and confronted about, we think you have our customer list. Appellants were evasive, express statements were made. If you or Bert had that, or if you or Anthony had that list, we'd think it would be theft. We'd think it would be a problem. There's no equivocating here. It was denied and it was evaded. The reason why that fact is so important is it destroys literally every other argument regarding the trade secret that appellants have made. For example, appellants knew it was valuable. If we're looking at the elements of what it takes to be a trade secret, they wanted it. They wanted to use it for their competing business. They knew it was protected. They went to Patricia Bravo to get it. According to them, she's denied that she gave it to them. They couldn't get it on their own, even with whatever access they had on their iPad. I think that that's a bit of a red herring. They didn't get to what this list was that they ultimately got.
Let's focus on that for a moment, because it seemed like the evidence established that some data was transferred from and lined up and reconciled. But there was no, from what I've seen, testimony that all of the data in the computer, in the customer list, was placed on an iPad. It was just customer job by job.
Correct. That's the testimony. That's my understanding. My understanding is further that only the owners, Mr. Resende and Mr. Sherwood, are the only two people who have complete access in the jobber system. All other users have a profile, and there's a list of permissions that are checked, and neither Greiner nor Schmidt had that unlimited access. They had the access level appropriate to the job that they were performing. That is the testimony that was provided at the evidentiary hearing. And so there was no evidence there that the iPad, what was available on the iPad, was the same information that was on the Exhibit A that's been submitted here.
Well, not the complete
Correct.
same information.
Correct.
Same information for a particular job and reconciled perhaps for
Correct.
phone numbers or emails.
Correct.
Okay.
So the coming back to the telephone call, that's important because they knew it was protected. They knew they didn't have access to it. They knew they needed somebody else to get it for them. They knew they couldn't get it somewhere else. They knew it wasn't publicly available. And their actions in concealing the fact that they had it confirmed that they knew it was secret. The trial court found this very persuasive and held that this alone undermined their credibility as they made assertions about other matters. So, and this fact is indisputed.
And isn't that part of what makes it so difficult on the other side? Because there's an abuse of discretion, a credibility finding, and finding that a particular witness and what they had to say wasn't credible isn't something that we can really look behind for an abuse of discretion.
Correct.
The subject matter of what's on the list is interesting. So there's a lot of people and businesses with whom Arborcraft did business, right?
Yes.
Okay, but not everybody in this database is someone who Arborcraft successfully did business with, right?
Correct.
So there are some businesses or people with whom Arborcraft would like to do business but hadn't yet done business, right?
As far as I understand, yes.
So when you're saying that the list is not publicly available, and I as far as it goes, I agree with that, but the information in the list, like that exact compilation isn't publicly available, but, people who you might solicit for, this kind of business, or, you can just find that on Google. So, if 10 or 20% of the list content is publicly available, why isn't this an overbroad injunction in so much as you don't even have established customer relationships with some significant minority of the list. So why should they not be allowed to solicit your non-customers? That's confusing to me.
Sure. I think it's I'm forgetting it's the Khaleesi case, Khaleesi versus Unified Financial Services.
Is that a California case, that one?
No, I think it's an Arizona case.
Okay, sorry.
There's two ways that a customer list can be a trade secret. One way is through, some of the value that the information has. That's an issue that they've hammered on. The Khaleesi case says it can also be a trade secret when considerable effort and resources have been expended in compiling this list. And I know that there are other cases, the citation escapes me at the moment, that have, in Arizona, reaffirmed that principle that there is value in compiling this information over time, regardless of whether or not there is, in fact, a customer relationship that actually is consummated between the individuals. That's the whole, they're trying to grow this list. So,
But let me ask you, to focus on this, the idea then that they can't take a passive phone call from somebody on the list, when this may be a passive phone call from somebody with whom your client never did business. It seems to me that that's a bit more of a challenge.
I agree that it's a challenge. I would come back to what the trial court said its objective was to balance Arborcraft's need to protect its trade secret on balance with appellants here took something that didn't belong to them. And that creates some rough edges, to be sure. And we've been trying to work through those rough edges. But I would submit that from appellant's point of view, it's a little bit disingenuous to have stolen something, put it out into the universe, and then cried foul when someone can call back off of that and they have no culpability going forward for what it is that they had done. The trial court's intent was to balance these two things and so as to ultimately help the parties move forward towards a resolution.
Isn't that where it becomes a damages issue? And that in the end, if they end up with a customer that they got off of your list in that fairly narrow area, that you're going to be able to say, look, the only reason you even knew to contact them was off of our customer list. You're going to get into a damages argument because that's going to be part of what comes later on anyway.
I think that yes and no. Damages always requires some evidence of, some specific evidence that can show that relationship. Arizona authorities are clear that a relationship alone and the potential to lose that relationship is a irreparable harm sufficient to support an injunction. And I'm not aware of any authorities.
But some of these people, you don't have a relationship.
Well, I agree. But, a relationship starts at a contact, finding information, and cultivating this going forward. At what point? So I would submit that from Arborcraft's perspective, they have a customer list and they send out marketing to these customers. Businesses worldwide do this, and they get a response from that and they make money. If, because of having misappropriated this customer list, appellants then are able to intercept that opportunity and take it, I think that that's a harm that they would suffer because of the misappropriation. If they can separately demonstrate an independent connection with this customer, then they had an independent connection. This was our first part of this discussion. I see I'm getting close on time, but it's...
But you don't have an independent connection with a non-customer. That's the analysis kind of falls down for me right there.
Well, I think that it's a prospective customer. I think businesses have forever sought to find individuals to market to them, and that information itself is so valuable, and to have someone else steal that information, and the only reason why they have no responsibility for having stolen that is the mere fact that there was not a fully consummated relationship beforehand. I think the...
Or any.
Well, there was enough of a contact to have obtained, there's enough to have acquired the information somewhere. The Arborcraft puts out emails, marketing, social media, how all of this information comes back to them, whether or not this person retains is in large part based on efforts and resources that it has spent to getting these things in.
But under the case law, you would much more clearly have a protected interest in a customer list than a list of potential or prospective or desired customers, right? Like you'd have a much stronger interest in that part of this injunction than the other part, right?
I would agree that it's much stronger,
Okay.
but I would respectfully not cede that there's no value in a unconsummated relationship. I see that I'm out of time. In conclusion, we request that the court affirm the order of the trial court.
Thank you, Your Honors. I know that I have a limited time.
And
so-
counsel, is there a way to more narrowly tailor this injunction order to take care of the problem we just spent the last 6 minutes discussing, or is there no way to do that?
No, I don't see how that could be done, Your Honor. That's why I filed the motion for reconsideration to try and narrowly tailor it, and the judge rejected that attempt. So first of all, as to the issue of the standard of review, I do want to clarify my earlier response. That yes, this is an abuse of discretion standard, but there is also a de novo standard for granting injunctive relief for an abuse of discretion where you're reviewing legal conclusions on a de novo basis, but you defer to the court's factual findings unless clearly erroneous. Respectfully, if there's unopposed testimony, then how could that be disregarded by a court when there is no testimony offered to the contrary by the other side? As to the issue of this independent connection that was just addressed by opposing counsel, there is the order states that my clients are prohibited from having these contacting individuals predating 2019. First of all, Your Honors, one of my clients didn't even start working for Arborcraft until 2022. We asked for that clarification from the trial court to state that they were only prohibited from contacting folks if it was during his actual employment with Arborcraft. That was declined. And respectfully, how can Arborcraft have an interest in, how could my clients be precluded from contacting individuals that they have their own independent relationships, even that overlapped with Arborcraft, without a confidentiality agreement being in place? Lastly, the Khaleesi decision that we were just talking about, there's two prongs there. The first prong, customer list, is not entitled to see, we've cited to case law in our briefing that trade secret protection is not available when it's simply a client list with contact information. I think that's fully briefed. It seems that the other side is trying to argue this second prong of substantial efforts, but there is a paragraph, I want to draw the court's attention to paragraph 22 in the Khaleesi opinion that states you have to show some evidence that there were substantial efforts that were made in order to compile the list. The only testimony on this was the $350,000 the Khaleesi decision lays out. It was in the opposite in that case, of course, but the record is completely silent regarding the cost, time, frequency, and success rate of mail advertising or use of the marketing method. There were none of those other indicia of substantial efforts to develop the list in this case.
And counsel, I see you're at your time unless there are other questions. I'll give you one sentence to wrap up.
Your Honor, this case is simple. It's where my clients tendered their resignation. They were provided the client list at issue on a voluntary basis by the office manager. My clients did not misappropriate anything. In fact, the testimony in the record shows that Arborcraft has zero evidence that my clients downloaded the list at issue.
Thank you, counsel. We appreciate your time and your arguments here today. We'll take this matter under advisement and issue our decision in due course. We will stand at recess.